Please be seated. We'll hear argument in case number 240293, in re Greystar Development and Construction.
May it please the court, Ms. Johnson will present argument for the relators. The relator has reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court. The issue in this case is whether the $25 million statutory cap on supersedeas bonds can be multiplied when there are multiple judgment debtors and a massive judgment. The answer to that question is no, based on the text, structure, and purpose of Chapter 52 of the Civil Practice and Remedies Code. First, the text of Section 52.006B2 plainly states that the amount of security for a money judgment must not exceed $25 million.
And when you plug in the definition of security that's provided, it says the amount of bond posted by a judgment debtor to suspend execution during appeal must not exceed $25 million. So why is that not an indication that it's per judgment debtor?
Well, Your Honor, for a few reasons. We think, first of all, that definition of security in 52001, which predates the 2003, it's a 1989 provision that predates the 2003 tort reform amendment, certainly does not permit cap stacking. There's no way to read that provision, even if you import it into the plain language of 5206B2.
A judgment debtor seems to be singular.
Well, Your Honor, I guess I'm most reminded of Justice Scalia's statutory interpretation comment that Congress does not hide an elephant in a mouse hole. And their interpretation of security, of importing it into the statute and interpreting it as an exception to the $25 million cap, a massive exception, that means that it can now be multiplied multiple times.
Well, when you're talking about, what this is all about, this is about protecting the person who has the judgment, who's owed the judgment. I mean, that's the main protection. And then a counter protection is to make sure that you just don't drain the debtor dry. But, it's certainly not as if this whole area of the law is meant to protect the debtor.
That's true, Your Honor, but that was
the purpose. Let's not lose sight of that,
That was the purpose of Chapter 52 when it was enacted. It was the quote was from this court's prior opinions on that, I think the Nally case, it was to strike a new balance.
But still a balance.
Still a balance, Your Honor. And there are many protections for judgment creditors in here beyond the requiring the significant posting, I might add, of $25 million. This is not
both interpretations in this case seem to give the debtor quite a bit of relief, right? Because even posting $25 million apiece is quite a bit less than they would have had to post absent this rule, even on their several portion of the judgment, even without joint and several liability, right?
Well, the whole liability is joint and several, Your Honor. It's $360 million.
Right, but the jury also found the percentages of responsibility, and I think the lowest, even if there was no joint liability here, it was only several, I think each party's amount that they would have to post would exceed $25 million.
Based on the compensatory damages in this nuclear verdict of $360 million in non-economic damages for a wrongful death case, yes.
And so it is doing a reduction under either interpretation.
Well, Your Honor, yes, but let me point out because this is an important point. The point of the Chapter 52 enactment in 2003 was to codify a policy shift towards more protections towards the judgment debtor. In the wake of Texaco versus Pennzoil.
When you say protections of the judgment debtor, you mean protections of the appellate rights of the judgment debtor.
Your Honor, I apologize, yes. And again, I just want to pull back. This is not affecting to your point, Justice Bland, this is not affecting any substantive rights to collect the full amount of the judgment if it is affirmed on appeal.
And on that point, on the point of collection, security and execution seem to be as to a judgment debtor, and appeal rights are as to a judgment debtor, right? One of these individual defendants could have chosen not to appeal.
That's true.
And if if the other side's coming to collect on the judgment against any of your clients, that has to be on an individual basis, right? They would execute against the assets of any one of the people individually.
Well-
So why is it, I mean, if defendant A has a bank account, they're going to have to show up with a garnishment order against defendant A, not defendants A, B, and C. The execution is per debtor. And so why isn't the suspension of execution sort of naturally and appeals are per debtor, so why isn't the suspension of execution pending appeal also per debtor?
Well, a couple of answers to this, Your Honor. This is not about collection of the judgment. This is about
Well, it would be if
procedural-
there weren't a bond.
Yes, but this is
Isn't
about
that
what
I
is,
thought this was the security to suspend execution of a judgment during appeal.
right, but I just want to be clear that we are not talking about invading any substantive rights of a judgment creditor to collect the full amount of the judgment if they prevail on appeal. It's merely what is the right balance between securing a judgment creditor and letting a judgment, not crippling a judgment debtor during the pendency of the appeal so that they have this massive pressure to settle the case.
And the
let me just be
legislature
clear
struck that
about
balance, so we're just trying to figure out what the words say.
the judgment collection efforts that occurred in this case were enormous, and they were not limited to the judgment debtors in this case. They sent out discovery to non-parties. They instituted as soon as this bond was invalidated by the trial court, they instituted a proceeding in Delaware to go against our parent companies. It had nothing to do with the judgment debtors. So there was the judgment creditors in this case did not feel limited by the three judgment debtors. But let me go back to the legislative purpose of this statute, because the legislature decided in this statute to impose on a judgment debtor a significant requirement of $25 million. That was the balance that they chose to strike. And there is just no way.
On a judgment debtor.
On a judgment debtor, yes, which is a significant amount of money. And the other thing is they gave judgment creditors other protections. And I would point out one that you would think would have been employed here but was not, which is the right to impose an injunction. If they believe, even if we post a full bond for the full amount, if they thought they had evidence that we were dissipating assets to avoid satisfaction of the judgment, and that was not in the ordinary course of business, they could have sought an injunction against us. They never did. So this was all about harassing the defendants, putting intense pressure on them, which they did, to force a settlement of a nuclear verdict before there could be meaningful appellate review. And that is the balance that this court was talking about, that in the Longview case, and in that case, to your question, Justice Lerman, isn't this unfair? I think it was in Corral Lerma, this court essentially ruled that the plaintiff had no security in that case. But they said that's the way we have to read this statute. Because in that case, they found that attorney's fees need not be bonded, and that was the bulk of the judgment. So they said, look, we realize you have no security now whatsoever, but the statute prescribes what the bond must be. And that's exactly what we have here. We have the legislature did not create an exception to an absolute cap. That's what Justice Hecht called this in the Longview case, an absolute cap on the judgment of $25 million without regard to the judgment debtor.
So I want to be sure I understand how that would work. Say you had a case with two defendants and it's a breach of contract case, just several liability only, no joint liability. One of the defendants liable for $50 million and the other one for $40 million. And so in your view, if defendant B, who's liable for $40 million, posts a $25 million bond, that suspends execution against defendant A, who's liable for $50 million.
No, Your Honor, both
Why?
of them would have to be liable on the bond. That's the Fortune case and Jackson Walker. They would both have to be on there. That you can't have, you can't suspend, the defendant B could not suspend enforcement for defendant A, particularly if it were several liability. But even if it were joint and several, they would both have to be liable.
On the same bond, or each would have to have a $25 million bond?
They could each post a $25 million bond, but say the surety is not required is not on the hook for more than $25 million. I've seen that done in cases. That's what some cases do. The point of Fortune and Jackson Walker, now those are joint and several liability, but one defendant cannot, all the defendants have to be liable maximum amount of the bond, which
But you
be
would say if
25
it's
million.
several liability only, maybe they would have to post a separate bond.
Yes, because they would both have to be, whatever the amount of the bond was. I do think under our reading of the statutory cap, of this $25 million cap, I mean, it's particularly persuasive here, where you have 3 related entities, brought in as a joint enterprise, joint liability, joint counsel, joint appeal,
But
joint
what were you
everything.
saying in the other case?
I'm sorry.
You were starting to say something else, and you said it's particularly egregious here.
Well,
But
right. So particularly egregious here, where everything is joint, we're a big joint enterprise, except when it comes to the bond. Now suddenly we are separate, and we've got to stack $25 million bonds, just limited by the number of defendants, number of our corporate entities that the plaintiff chooses to sue.
Well, that
But
seems
in
like a separate point, and I want to
Right.
ask your opposing counsel about that, whether we should basically treat these as one debtor because of the joint enterprise finding. But setting that aside, just
Yes.
in the contract case where it's several, you would say 2 bonds.
You could post 2 bonds, but I still think the maximum liability either debtor could be liable for is $25 million. I think the $25 million cap. I don't think the statute makes a distinction between joint and several judgment debtors and individual. And in fact, I think this is important, that the statute doesn't use the phrase judgment debtors at all in the plural. It doesn't appear in the statute anywhere. And I think the only way...
I think that's their point, which
Well,
is why...
right. But the only way to interpret that is that the legislature didn't think it was important. Whether there was singular or whether there were multiple, they wrote this statute knowing that litigation often has multiple defendants. And
So what about B1 under your interpretation? If you have 3 defendants and it's way more than 75, say you've got a $150 million judgment, joint and several against 3 defendants, and one is bankrupt. And so they post $1. And say all 3 defendants get together on the $1 bond, and they're jointly they say that's going to be plenty, we're each obligated to pay $1.
Yeah, that wouldn't work because
Why?
the net worth cap is tied to the individual judgment debtor. Because
Well,
it is
it's
tied
with the
to...
exact same, it says the judgment debtor's net worth, but even the other one is a bond posted by a judgment debtor to suspend execution.
Well, no, I'm sorry, Your Honor, but no, the judgment debtor actually is in 52.006B1. Net worth is an individual analysis. It has to be done on an individual basis. There's no way that solvent judgment debtors could jump onto a net worth bond of one insolvent judgment debtor. They would, in that situation, that insolvent judgment debtor could post the $1, but the other 2, if they didn't have the net worth issue, they would be subject to the $25 million cap.
But if you incorporate the meaning of security as a bond posted by a judgment debtor, then you're saying the amount of a bond posted by a judgment debtor must not exceed $25 million, and that's also, you've also got a reference to a singular judgment debtor.
Well, Your Honor,
in the language
we
that comes
suggest
before
that
either 1 or 2.
Security throughout this statute and in Chapter 5206 is tied to the judgment. And the phrase "a judgment debtor" in the definition of security is an indefinite article. It doesn't connote that it has to be singular. It can mean any judgment debtor. Experts on legal drafting recommend using the singular over the plural. This is from Justice Scalia and Brian Garner. The proposition that many ones includes only one is not as logically inevitable as the proposition that one includes multiple ones.
Are there any restrictions on the judgment debtor now in terms of transferring assets? Okay, so those are all
In our
in place?
case, no, there are
In
not.
your case, there are none?
No, because
And-
they weren't sought. And I think that's a huge red flag, Your Honor,
Well,
that they didn't
hold
seek
on.
that.
So
Yes.
you're not contesting that there could be other sorts of injunctive restrictions on the debtor's use of whatever resources or assets it has,
If they have evidence using
in
24.3D.
addition to whatever, whether it's
Yes.
25 million or 75 million?
Yes.
Okay. And then what is the status of the case on appeal?
It is fully briefed and it's set for argument in the Dallas Court of Appeals in early November, Your Honor.
Does it seem strange, at least, that if there were a case that could have been argued as 2 different cases and each could be secured by 25 million, but through procedural requirements of efficiency or, sometimes mandatory, sometimes permissive, it just ends up being one judgment that substantively everything is the same, but there would just be $25 million because we have efficiently conducted litigation rather than two $25 million?
Yes. I mean, I don't think there is any way to read this statute as a textual commitment to cap stacking. And there is no way to read this security as untethered from the judgment. And there is only one judgment. There can only be one judgment. And therefore, there can only be one $25 million cap, which is both adheres to the text and makes a lot of sense.
But if you could do in a, not this case, but in others in which the defendants were not going to be jointly and severally liable, that there might have been a way to have one lawsuit against this one and one lawsuit against this one.
Oh, right. I'm sorry, Your Honor, I misunderstood. If there were multiple judgments,
Yeah.
yes, there could be multiple caps.
And so
because the
just
cap
by-
is tied to the judgment.
That's right. And so then just by whether it's adventitious or whatever else, we just happen to procedurally aggregate into one. Just the consequence of that, just too bad. That's the way it goes. That's your argument, or?
Yes, that is, I mean, I think there's reasons why the plaintiffs chose to sue multiple related corporate entities. And this is one of them, to put intense pressure on a defendant. But they didn't want to have multiple trials.
Do you think that we have to decide the question of whether, when it's only several, the $25 million cap is also limited per judgment? Do you think that's essential to your position?
I don't think it's essential. I do think a close reading of the text, it's hard to see a distinction in the text. I mean, Justice Busby might have suggested one where if you have joint and several judgment debtors, that's essentially a judgment debtor because everything is joint. Joint enterprise, joint and several liability, joint judgment, joint counsel, joint appeal, joint everything.
Could a trial judge render two judgments, one against one defendant and one against another?
I don't think so.
No?
Not under this court's jurisprudence. There's only one final judgment that can go up on appeal. If there had been multiple trials, that would be a very different situation. Multiple trials and multiple judgments.
Let me ask you about in 24.2b, where it states that the trial court must lower the amount of security required by A to an amount that will not cause the judgment debtor substantial economic harm if blah, blah, blah. How do you think that plays into your argument?
Well, Your Honor, those are other protections for a judgment debtor. It's basically, there's three things available to a judgment debtor: the net worth cap, the $25 million cap, and if there's something, I think that goes really directly to the Texaco-Pennzoil situation. If it is going to cripple the defendant, if they're going to pull up a truck and put the assets of the company in the truck, and so you can't go on an appeal, you can't have an appeal, then that's the substantial economic harm. So there is that discretion in a trial court. But before you even get to that, you have the benefit of an absolute $25 million cap and a net worth cap that's based on the assets of the judgment debtor.
Could I ask you about the Rule 24.4A motion that you filed in the Court of Appeals? Which of the 24.4A 1 through 5, which of those things was the Court of Appeals reviewing?
I'm sorry, Your Honor, I'm gonna, the 24.4A 1 through 5,
Yeah, so it says the appellate court may review the sufficiency or excessiveness of the amount of security, the sureties, the type of security, the determination whether to permit suspension, and the trial court's exercise of discretion under 24.3A. So which of those was happening here? Because I understood your briefs to say that none of those things were happening because there wasn't either an order or a modification after the plenary jurisdiction expired.
Thank you, Your Honor. That helps me understand the question. Yes, that is our position, that none of those things were happened, that they were prescribed under the trial court was very prescribed under 24.3A after plenary jurisdiction has expired to only doing two things, which is order the amount and type of the security and modify the amount or type of the security. What happened here was an instant cancellation of our bond. It happened with a stroke of a pen. Immediate elimination of all the protections of the bond. The plaintiffs immediately went out and domesticated judgments in Delaware, went after our parent corporations, issued hundreds of sets of discovery to non-parties.
Well, perhaps when you come back up on rebuttal, you can tell me whether it was 1, 2, 3, 4, or 5 that the court below was talking about, just in case there's a jurisdictional consequence of that.
Thank you, Your Honor.
And just to follow up on what you just said, what would you suggest the rule should be in a case where imagine a case where it would be appropriate for the trial court to say you have to post a bigger bond or you have to post an additional bond. Regardless of whatever the reason is, assume it's a good reason. How long should the trial court give somebody to do that before execution? What standard would you have us craft for when it's an abuse of discretion to not give somebody time to comply with that before execution can ensue?
I think the rule gives us the answer to that. It's 20 days.
Well, it doesn't quite give us the answer in this circumstance.
Right.
It says
That's right,
20
Your
days
Honor.
if the Court of Appeals modifies.
I
It says
agree.
20 days if the net worth is modified, but
Yes.
it doesn't quite address this circumstance. So
I
would you
agree,
say
Your
we
Honor.
kind of borrow from that and say 20 days is?
I do, Your Honor. I think that would be, I think you're safely within your discretion. That's the time frame that has been decided is sufficient time for a judgment debtor to be able to go out and get sufficient different security. So I do think, I agree, there's a little bit of a gap there, but I do think 20 days is the right answer.
Any further questions? Thank you, counsel.
Thank you.
We'll hear from the real party.
May it please the court, Mr. Henry will present argument for the real party in interest.
May it please the court, Mr. Chief Justice. I'd like to start by the text that Justice Busby mentioned. The plain reading, if you import the definition, clearly, say clearly, you're not supposed to use adjectives in appellate law. I think I've heard that at y'all's research and right, but it is hard to say it more clearly if you import the definition from 5201. And the idea that it predates 2003 rule changes helps us because the legislature basically repealed all the other provisions that would have affected this and left in place the definition of security to apply to the rest of Section 52. So if you just read the definition as Justice Busby read it and as it is placed in our brief where you just import the definition, it is hard to escape the singular judgment debtor being applied per judgment debtor just as the same sentence includes the net worth. It would be, here's what you have to post, judgment debtor, 50% of your net worth or $25 million or less. It would be like me saying to someone, the price of admission to this ball game is half of what's in your pocket or $5, whatever's less. The subject of that sentence is the person trying to get into the ball game. It's not half for them in their pocket and $5 for every other fan in the universe. It's $5 in normal vernacular if I was talking to someone. It's $5 for the person standing there trying to get into the ball game, not all the fans in the world. So just common usage, besides the specific definition, tells you that this is per judgment debtor. Moreover, every single other provision in Rule 24 and Section 52 is by the judgment debtor. By judgment debtor, not collective, not multiple judgment debtors. This would be the sole provision, despite the definition provided by the legislature, in which the court would say, in all circumstances, we consider this a per judgment debtor rule, net worth, injunction rule, relief under the C, under 5207. There's a new $10 million relief net worth provision in the rules and in the statute in 5207 for judgment debtors under a net worth of $10 million. So an additional protection for judgment debtors. So there's multiple protections for judgment debtors. This would be the only provision in which you would scrap all of that and say, but for this one phrase at the end of a sentence that deals with a judgment debtor's posting of a bond, it applies to all judgment debtors and the entire judgment.
You had a judgment for $50 million and you had 10 judgment debtors jointly and severally liable. How much would each of them need to be bonded for under your approach?
So if you had a judgment for $50 million and it's joint and several, so setting aside the fact that this is joint and several, Justice Busby mentioned several liability, and I'd like to address that, but under your hypothetical,
They're all responsible for the judgment jointly.
that's right. They're each, and so the statute and the rule does not concern itself with why someone owes money. It could be the worst possible theory in the world that was tried to the trial court, one that this court has rejected. This is not about merits or about policy of why someone.
There are 10 of them.
There are 10 of them. They're each.
If they each have to pay it, you're only going to get $50 million in the end. What supersedeas is required for each of the 10?
Each of the 10, well, the maximum amount of the judgment to start, each one of them has $50 million plus interest on appeal and costs. If they use net worth, then they get to reduce their own.
The net worth is enough.
Okay, so each one would have to post a bond of $25 million.
We're going to have $250 million
Well-
of security.
Well, because it's one injury here, this is where it differs from several. Each one still needs a $25 million bond.
But why couldn't they post it jointly?
They can post a joint bond.
And,
They can-
and say, we're going to pay out 25 million no matter who you would come after. Say 9 of them are reversed on appeal, but one of those defendants in Justice Young's hypothetical, the judgment against them is affirmed. And so you're going to want to collect against the one, obviously, that held up on appeal. But if the bond says, we're going to pay 25 million regardless of who you're executing against, why wouldn't they only need to post one $25 million joint bond?
Because each one is liable for more than the cap. And if the cap is per judgment debtor, that judgment debtor needs to supersede the judgment it owes subject to the cap. So that one would need a $25 million bond.
But they've each posted a $25 million bond if it's a joint bond, and the language of the bond says, we're going to pay out 25 million no matter what. For whichever of these defendants you execute against, we're going to pay out 25 million.
That's correct. The problem is that you need each judgment debtor to be fully secured, and you need to know which ones have posted the $25 million bond. So if you look at a situation where it's below the cap, you can easily see what happens. Each defendant posts, if a $24 million judgment, each defendant, even if it's joint and several, by the way, each defendant needs a $24 million bond in a case that's below the cap.
Well, yeah, my
If it's
hypothetical
above the
is
cap,
they'll pay out 25 million on any of the defendants you execute against, up to a maximum of 50 million. Why wouldn't that be sufficient if it's a joint bond?
Up to a
maximum of whatever the judgment plus interest and costs.
Because each judgment debtor needs their own bond for $25 million, because they're taking advantage of a cap where I would have been able to collect against that judgment debtor for $50 million.
I guess I just don't see in the statute where it's talking about whether the bond is joint or separate.
I agree with that, and I do not think this case is about joint bonds. I do not think that what the court does here in construing the statute of requiring a bond for the full amount, whether the cap is per judgment or per judgment debtor, has to transcend into whether or not joint bonds. I believe joint bonds have been allowed, and no one on either side has challenged the venerable precepts of number one, joint and several defendants have to all post or all secure the judgment up to their maximum amount they owe. No one contends that should be different in this case. Neither side contends that joint bonds aren't allowed. And in fact, in a case that I share with my co-counsel in Dallas Court of Appeals, same one that issued Greystar, in a case called Sun Holdings versus Stockton, which is at 2025 Westlaw 2009-7720, had a case where it was below the cap, and the judgment debtors posted a joint bond up to the full amount of the judgment, such that anyone could be collected up to that amount, except the surety was capped at the amount of the judgment because it was all one injury. It was all joint and several. So that, in that case, so the Dallas Court of Appeals knows how to apply joint bonds and knows they're allowed. It allowed it in that case. It just made the other side, in fact, ironically, was arguing that was insufficient security, and each one needed their own bond for $18 million, which is odd considering what we're doing here today. So I don't think there's any issue here. Their position is you want to cap the 25, and that has nothing to do with joint and several. They're asking for the court to interpret a rule that applies to all judgments. So if you have 4 defendants in a case that was tried together, and they're all severally liable, separate damages. One's got an out-of-pocket measure, one's got a reliance measure, one's got an injunction, the other one's got a property interest. So they've all got different ways they have to supersede the judgment. They're saying that setting aside this joint and several joint enterprise issue that applies in this one case, $25 million is the kit and caboodle for all liable defendants in a case under a final judgment, even if the judgments, the decretal language in the judgment as to who owes what are several as to all the defendants. And I don't...
Could you sever the case? I mean, I can imagine in situations in which it really is just like a collection of suits that could be brought differently, there could be severance. That's an available thing. And then you have different judgments, and each of them could be...
After judgment's a little bit more difficult than before you get a judgment. I'd also say that in a commercial case, the other side looks at this case in a traditional plaintiff's tort case with multiple defendants that are joint and several liable for an injury. That is a subsection of Texas jurisprudence. That is not commercial world. In commercial world, you have cases where someone's got a breach of contract claim, which can't be joint and several. It's just to the parties on the contract. Then you can have a fraudulent inducement claim and aiding and abetting claims, conspiracy claims for torts, which can be in the exact same commercial case. So there are a number of judgments, which include not only several liability, but several liability for different sets of damages, not always the single set of damages. Their rule, and there's no way to put it because the rule in the statute doesn't provide for distinctions.
Well, I think I heard them concede that in that situation, you'd have to post 2 bonds.
But
In the two different contract judgment debtors.
But the only way you get there under the text, that sounds like a very good idea to make a rule that way, but the text doesn't allow that. You would have to craft a rule
Well, it
that
does under your interpretation.
Well, under what the court could say, which I don't think this is textual, but you may think it's a good idea policy-wise to consider any defendants that are joint and severally liable, especially ones that are based on a joint enterprise or an alter ego theory, as one judgment debtor. There is no basis in the jurisprudence with respect to judgment debtors and nothing in the rule or the statute that would support that. But,
well, except that if you have an alter ego finding that they're basically all one company because they've abused the corporate form or whatever, then why wouldn't you consider that in interpreting the word a judgment debtor if they've been found to basically be all the same? And I understand this is a joint enterprise case, not an alter ego case.
Because you can still get a judgment, Justice Busby, against the individual and the company. And you would be collapsing them and basically hamstringing the ability of the judgment creditor to collect by considering them one. When considering them one can make them vicariously liability, but you'd have to do that almost for all vicariously liable cases. And in a lot of these cases, you can get a judgment against both. And you would be saying that it's not 2 people, but that would mean the rule means a judgment debtor that owes money, because and this goes to kind of Huff Energy's, and the discussion of a one final judgment rule is kind of a straw man. We all know there's one final judgment for purposes of plenary power and for purposes of appeal. But for purposes of the rule, when the rule talks about if the judgment is for money, it's not talking about you decide whether or not this entire judgment with 15 different provisions is a money judgment or not a money judgment. It's talking about the decretal award of the judgment. Because you can certainly have one final judgment that has a judgment for money, a judgment for injunctive relief, a judgment or an order for declaratory relief, a property interest. So you can have...
So I understand that, and also your point about the definition of security. But how does that square with amount? The amount of security must not exceed 25 million.
You engraft the definition of security, as Justice Busby read and as we've briefed, that says that security in that sentence means a bond or deposit made by a judgment debtor.
So security is a bond or deposit, so the amount of security, the amount of bonds collectively, deposits just the amount shall not exceed the lesser of the 2 numbers.
But the definition is more than it doesn't define security as a bond or deposit. It defines security as a bond or deposit by a judgment debtor.
Right.
Must not exceed. So by a judgment.
So the amount is also tethered to the amount not exceeding 25 million is not tethered to the judgment for money, but to the
It's tethered to the number of debtors. It's tethered to a singular debtor.
But not the judgment for money.
That's correct. Well, the judgment for money is any order to pay money. So you can have 5 orders for money, even though you have one final judgment. You can have 5 judgments for money in a judgment. In other words, no one's arguing that if there's 4 provisions ordering the payment of money, each one of those provisions need to be superseded. It's not a...
Because you might also have a judgment to turn over property or for something that's not money, and then there's a different rule about how you supersede that part of it.
That's right, and that could be in the same judgment. In fact, because of the one final judgment rule, you are required to include all your relief, injunctive, declaratory, cancellation of a lien, you name it, in one judgment. So sure, there's one final judgment, but for purposes of what you have to supersede, in one final judgment, you could have a judgment debtor superseding money, the same or a different one superseding property, and the same or another one superseding a declaratory judgment.
It only affects judgments for money, and you can obtain alternate security for judgments that are for other than money.
That's correct. And that's per judgment debtor as well, not per judgment. It's obviously tied to the judgment debtor. A judgment debtor has to go and get that per judgment debtor. It's not a global rule that once one judgment debtor supersedes a judgment, it's superseded as to all. And that is the question here. And I do not see how my friend on the other side gets to, if one, under their reading, if one appellant, one judgment debtor posts $25 million, under their reading of the rule, no security for that judgment can be required other than that $25 million. I don't know why.
No, it has to secure the judgment, and if they're not on the bond, it doesn't just secure anything with respect to them, right?
Well,
I think that was their argument, that.
Well, if there's
and you were saying earlier that you can have multiple people on a bond. So the question is whether it's one bond for $25 million with 3 judgment debtors, or one bond for $75 million with 3 judgment duders, or 3 individual bonds with, it's a very complicated matter.
The better question is why? Why does it have to be the same judgment debtor for 20? Why can't it be one judgment debtor for $1 and one judgment debtor for $24,999,000?
Because that wouldn't secure the judgment.
Well, it would. It would be the $25 million cap. The amount of security for, under their theory, it's a collective rule.
I think is it the point that if any one of them ends up being upheld, liabilities upheld, the bond has to ensure that you're going to get the $25 million, even if they don't have other assets. So you're going to get that no matter what. Whereas if it's $1 for one person and $10 somebody else, well, if that's the only person that it's upheld for, you're going to get $1 and not $25 million. Whereas under your interpretation, it seems to me that you have sometimes the accident of multiple people, and so if the exact same thing had happened to somebody with only one responsible party, they're getting $25 million secured, whereas just by virtue of having multiple people involved, you're wanting security that is multiplied above that. That doesn't seem...
Because it's multiple judgment debtors, and we need security against each judgment debtor in order to be able to appeal. They have to secure enforcement against them. This is
agree with that.
Judgment debtor's right, which means if that judgment debtor doesn't post the full amount that they're owed under the rule, if they don't post it, then they are subject to execution.
Yeah, and I'm saying if any one of them does not succeed in overturning the judgment, you would get the same thing with a joint bond for $25 million as you would have gotten if there was only one defendant all along and they don't succeed in overturning the judgment. Except
that their position goes beyond a joint and several liability situation and asks the court to interpret the rule to be for all judgments, the $25 million is a cap on total security.
And so I'm not certain that we have to decide that in this case. Do you think we have to decide that in this case?
Absolutely, because there's nothing, unless you would graft the court's own rules about joint and several reasons why you're liable as opposed to the fact that you're liable. In other words, the way the rules are written now, it doesn't matter that they're liable in a specific way. The rule and the statute treats it as they are just as liable as joint and several liability debtors for the same damages as if they were several debtors. The rule and statute does not have any text or explanation that you can treat any judgment debtor differently except the fact that they owe money. Not why they owe.
There'll be some oddity that happens as a result of this decision, no matter what. One of them is that if you prevail, just by virtue of having multiple defendants, you get to be super secure. In fact, to the point that you are so saturated in security, 10, not in this case, I'm sorry, but the theory would be you got the 10 people each having a $25 million bond for a $50 million judgment. I mean, that's like super over secured. Under their reading, if we go to this several liability, it's possible that there may be, if you look at that just as a judgment, that might be undersecured in some ways, supposing those had been different judgments and stuff. But there's no way to avoid something that might not be perfect, in a platonic sense. And that might be for the legislature to fix no matter what we do, or think about it some more no matter what we do. But why is yours the only possible way?
So ours hews to the text, and if by accident, I don't believe that's necessarily oversecure, because in the joint bond cases, for the same damages, the surety still can limit its liability. In other words, the surety can limit its liability, as it did in the Sun Holdings case. It's not a cap case, but it clearly is. Each one has a bond for $18 million in full. But the surety isn't liable for anything more because it's joint and several. So that's where joint and several has kind of been fixed by this court's jurisprudence and the practice of you can't collect more than once. So you're not going to really get over bonded under the joint bond, joint and several liability rule that already exists.
The
You don't-
economics of the
That's
supersedeas,
right. You don't need to mess with the text and engraft an entire new rule that changes this from a per judgment rule. And let me just talk about the mischief. It is not evenly balanced that one, maybe we have an extra two $25 million bonds. The other thing is what no one has addressed, at least not today, is there are so many ways that bond amounts get adjusted intra-case. So you can have an entire litigation for 6 months over someone's net worth affidavit, and at the end of the process, their net worth can be raised while the case is going on. Having a per judgment amount that's a cap for all judgment debtors, that would need to be reassessed, because what if I'm one of the judgment debtors that posts the bond and mine gets reduced later on? Now I can post a less bond, and now there's a gap between the bonds posted and the 25 million. They're dealing with a case where 3 joint debtors post all the way up to the max and no harm, no foul. You have to think about a case when there's multiple judgment debtors that aren't friendly. Some may or may not appeal. Some settle while the case is on appeal, use the cash to pay off their judgment. Their cash deposit comes out. They're no longer part of the $25 million cap. They posted for $5 million, everybody else posted for 20, and we've got 25 million, right? Because theirs is a per judgment cap. So if someone's posted for 5, there can't be under their theory, there can never be security in toto for a judgment, regardless of the kind of the judgment, other than 25 million. That's the must not exceed that they have to live with.
And a friend in opposition, which of Rule 24.4A1 through 5 was being used? Your brief suggests that it was 24.4A2, that the Court of Appeals was reviewing the sureties on any bond. Is that still your position? And if so, in what sense was the appellate court looking at the sureties?
I believe it is regarding the amount. I mean, sufficiency of the sureties tells me that they're looking at whether or not the surety itself has the means to back the bond. But a trial court has to have the authority to review after plenary power, because 90% of supersedeas practice that I do happens after plenary power. So all the fights happen after plenary power in my cases. So they have to be able to order the amount. And what is really happening under 24.3 is the court is saying the amount you posted is X, whether it's this case or a routine case with multiple defendants that are severally liable. You don't have enough to meet your obligations, which by its very nature is a determination of the amount. You posted 20,000 in a regular case. The actual amount should have been 22,000. You're insufficient. And since there's no grace period in this section, but there's a deliberate grace period in another section, that automatically, when the court rules that that's insufficient, means they don't have suspension of the judgment. And that's balanced, may I finish my answer, Chief Justice? That's balanced by the rule that no matter how defective your affidavit or bond is, the law gives it presumption of suspension until the other side goes and gets a ruling. So I can post on its face insufficient bond or deposit. I get the benefit of supersedeas and they can't execute until I get a trial court to say otherwise. The counterbalance to that is when the trial court says otherwise, if it's in a net worth standpoint, you get 20 days. If it's not in a net worth standpoint, as of the trial court's order that you don't have sufficient posting, you are subject to supersedeas, no partial supersedeas.
Why shouldn't you get at least a reasonable time to cure?
As an appellate lawyer who deals with this issue, I believe you should get a reasonable time to cure. The problem is that the statutory scheme or the rule that the advisory committee put out following the statute does not provide one, and unfortunately it expressly provides very detailed ones for the trial court and the Court of Appeals in other situations, which tells me it's a deliberate choice not to provide a grace period. A trial court can. I've actually had it where a trial court has written in 5 days or 10 days on their own discretion.
So if a trial court has discretion, then why wouldn't it be an abuse of discretion in many cases to say, well, too bad, you're just, they can do whatever they want and you don't have time to fix it?
It's hard to say it's an abuse of discretion when the law and the rules provide exactly what the trial court did. It's a different story if this court decides there's some sort of gap that was inadvertently left out and wants to graft on a reasonable, equitable grace period, which would be reasonable in my opinion. It would be very helpful. Unfortunately, as a textualist and as people that generally don't make reasonable decisions for the legislature or even the advisory council on the rules, it's not there, but it certainly would be helpful in practice because it is sophisticated parties that litigate these issues for long periods of time, and then you end up going to a hearing, and then they take it under advisement, and you get an order one day saying your bond's insufficient. All of a sudden, you're unsecured in the middle of an appeal. That is not a very pleasant place to be, no matter which, and it's a tough place to be. So I would concede that, Justice Busby. And if there's no other questions.
Any further questions? Thank you, Mr. Henry. Ms. Johnson, you have 5 minutes.
Thank you, Your Honor. Let me answer your question first, Justice Sullivan. Our motion for review in the Court of Appeals was based on 24.4A1 and A5, which was the sufficiency of the excessiveness of the amount and the trial court's exercise of discretion. I do believe they raised a challenge about the sureties in their reply, but the trial court's order specifically said, I have concerns about the sureties, but that's not a basis for the order. Let me just clarify a couple things too. We are not saying that one judgment debtor can post $25 million and secure a bond for other judgment debtors. As Justice Bland's comments, we concur with those, that every judgment debtor has to be liable on the bond up to the absolute $25 million cap.
I think the point on the other side is that at some point that security, which seems secure up to $25 million, falls away.
Which is
and
why
how do you address that? Or there's a conflict, and as the appellate proceedings move along.
Which is why the trial court has continuing jurisdiction and does the appellate court to address that. If there are changes about if the amount and sufficiency of a bond becomes insufficient because of developments on appeal, that's when you go back to the trial court. As Mr. Henry says, it happens all the time. That things change and you go back to the trial court and you say, we got to have a different bond. This bond is no longer sufficient. There is no way to read Chapter 52 as a textual commitment to cap stacking. There is no way to read it that way. There is no way to read Section 52.001 as a massive exception to what Justice Hecht called an absolute cap in 52.006B. Every place the word security is used in Chapter 52, it is tied to the judgment. In the title of 52.006, the amount of security for the judgment. In 52.006A, when a judgment is for money, the amount of the security. 52.006B, the same thing. It is always tied to a judgment. If the legislature...
You've got to have a judgment before you have to post a bond, so that's not surprising. But does that really tell us whether the security that's being posted is the security is by the debtor, it's not by the judgment. So I'm not sure how that helps us answer the question.
But the cap is applied per judgment, Your Honor, because the word, to take this word, a
the cap
judgment
is
debtor,
for the security, it's not for the judgment.
but the security is to suspend enforcement of the judgment.
Well, the security is a bond by a debtor to suspend execution of the judgment.
Yes, Your Honor. And if the legislature had wanted to permit cap stacking, if it had wanted to permit a limitless amount of $25 million bonds, only limited by the number of defendants the plaintiff chooses to sue, then it could have done that.
Well, it's not
could
a
have said-
limitless amount. There's a limited amount per debtor is what they argue, not an unlimited amount. They're not saying
No,
that they're
right.
entitled, for
Yes, Your
example, in
Honor.
this case,
It's
to
but
the entire amount of the judgment plus interest, which they ordinarily would be entitled to if it was a judgment under $25 million in the ordinary course.
Right. This really only comes into play when you have a massive judgment like you do here, an $800 million verdict, a $400 million judgment, and then you have multiple judgment debtors, and so it does.
Well, and I thought I
come
heard
into
them
that
say
play.
too that they wouldn't require you to overpost. So if the total amount of the judgment is 50 million in Justice Young's 10 defendant hypothetical, then the surety can say we're not going to pay out more than 50 million plus interest and costs. So you don't
That's
end
right,
up
Your
with
Honor. But-
25 times.
Let me just say this. If the legislature had wanted to permit cap stacking, it could have done that. It could have said that each judgment debtor has to
On the
file a
topic
separate
of
bond.
what the legislature wanted, I think we had a case last term about venue appeals where you sort of, you talk about this idea that the legislature knew there could be multi-party cases, but then when you look at the statute, it sure looks like they weren't thinking about multi-party cases. And I wonder if that's sort of what we have here, is this was written in contemplation of single-party cases, shouldn't have been, but was. And so should we kind of put aside any notion of, well, they must have been contemplating these complex cases. And then what do we do? Do we just follow the text as rigorously as possible, irrespective of the consequences, or do we sort of try and make it make sense in the context of a multi-party case that may not have been contemplated?
Thank you, Your Honor. I would say what we can tell from 52001 is that they were not thinking about multi-party cases. And I think that's because it wasn't relevant. It didn't change anything. It didn't make the cut, you couldn't multiply the cap, it didn't change any of the protections that they were putting in for judgment debtors. There was no difference if there were multiple judgment debtors or there was only one judgment debtor. That's the only way to read 52001 and 52006 together. What we know for sure is that the legislature has determined as a matter of policy that it is more important to protect the right to appeal than it is to fully secure a judgment creditor for every dollar of a massive judgment while an appeal is pending. And to your question, Your Honor, I think there's only one way to read the text of this statute. And this court, in every case in which it has addressed Chapter 52, it has looked at the purpose. And I would also commend the court to the TCLJ letter, which goes through very carefully the background of Chapter 52, the legislative history of it, this court's opinion in Longview, this court's opinion in Nal Plastics, in the Corral-Lerma case. All of those cases depend very heavily in interpreting the text on the history and purpose of the legislative statute.
Thank you, Ms. Johnson. Any further questions? Thank you, and thank you to all counsel. The case is submitted. That concludes the argument set for today, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.